here, ATP, we have the topic 3 on insolvency procedures in Kenya. So, what I find interesting about commercial transactions as a unit is that actually, let me not just call it most, all all the law you can find it post 2010. That is after the 2010 constitution. So all the reference texts, all the relevant reference texts for commercial transactions became post 2010. So that gives you a bit of allowance, because now you don't have to go back to the history and then translate the history to the current. Now all you have to do is start all the way to how commercial transactions were revolutionized, and the access to various government services was made easier. Because now, if you compare before 2010, or let me call it even before 2015 and before 2017, around there, because what I found is that before 2017, I'll use 2017. Before 2017, you find that most services. Now I will first generalize, then I will get to insolvency. So I generalize for the register of companies and the business registration service, because the register of companies, it's not only the register of companies were there. Yes, it's the register of companies, but now after 2017, when they now called it the business registration service, the rationale was that now we are not only regulating corporate persons, we are also regulating natural persons, because now natural persons at that point had become so big in terms of commercial wise. You can find that someone trading is in his own name, even without a business name, in their own name, and they are to move large amounts of money. And now the purpose of course of all these commercial transactions laws is to ensure that we have some sort of streamlination. We streamline the industry. So now, for example, let me give a very direct example. In terms of accounting procedures, we follow the International Financial Reporting Standards (IFRS). Because why do we do that? Because now we have to have a streamlined method of accounting. So that falls all the way to the procedures now we statutory procedures. Let me use the word statutory procedures. And now, with that, we are now at the word statute. So, what statute is recommended for topic 3? We have this Insolvency Act, and of course, as you read the Insolvency Act, you read it alongside the insolvency regulations. Then we have the Banking Act, and then we have the Insurance Act. Then we have the Kenya Deposit, and let me see, it's Kenya Deposit. We have the Kenya Deposit Insurance
Depository.
Yes, this one, the Deposit Insurance Act, the depository, and then we have the Central Bank Act. So there are 6 statutes that I would call very key to this topic. 6. The Insolvency Act, I have added the insolvency regulations along with the Insolvency Act because of the business registration service. Because you can see now at point F of that cause outline, you have the debtor's bankruptcy proceedings, the company administration process, the insolvency moratorium, and the liquidation of companies step by step. And now these BRS guidelines, they are drawn particularly from the regulations and the Insolvency Act. So you have to read the two side by side. The same way you have to read the Companies Act, the whole of it. And now, after you've read the Companies Act, now that's where you start reading now insolvency, you start reading the central bank. The Companies Act is the umbrella. So the Companies Act is added to this list impliedly, because now what we are referring to is commercial transactions, and the Companies Act has done so well in covering commercial transactions. Of course, in consideration of also natural persons. So That's why we have the insolvency regulations and the Insolvency Act. So as at that, I'd like to begin the presentation. I wanted to give just a brief overview so that we see what course outline we are using, and then so that when we start, now at least we can flow a bit, so that if we have to refer to a certain statute, then we go there and come back. If we have to refer to the Business Registration Service portal, because now what I want to stress is, so for example, let me give an overview of what this whole insolvency thing is. Na mkiangalia mtaona that in fact what exists in terms of insolvency is that insolvency is a government run department. So the same way, for example, we have the CTS for civil litigation and some parts of criminal is the same way. Now we have a BRS to cover now the 4 registries in terms of commercial transactions. So for these 4 registries, so I would wish if by the time we are having these sessions, I would wish I'd be able to take you through the 4 registries as a BRS, the Business Registration Service. So that is the company's registry. We have this insolvency registry. I want us to go through it today and we complete it. Then we have 2 more registries. So there are 4 registries. As I think I had mentioned earlier, but for today, let's now go through these 3. So I wish to start with the registry first. That is the site on BRS, because that's where the registry migrated to post 2017. And it is clear that the government is digitizing everything. So I think it's even for the better. I think it's even for the better, because you can imagine before then watu walikuwa naenda Sheria House huko hapa hivi, and you can imagine everyone in Kenya anaenda 16th floor Sheria House huko juu 16th floor, everyone in Kenya. You can imagine even running a company how expensive that would be. So for example, umefungua kampuni Turkana, you have to go to Nairobi to file just an annual return, na sasa hivi annual return unafile online just at 1,000 bob. But you can imagine the kazi walikuwa wanafanya hiyo time. So I think it is for the better with the digitization. So direct to the registry. Let me share this screen. So for this presentation, I wanted to take about an hour. So I want to take 15 more minutes on this registry, then the next 30 minutes discussing the notes that I had, and then we can complete at that, and then we have questions, and then we go on. So here's the registry, the office of the official receiver in the insolvency. Office at .receiver@brs.go.ke. So the Office of the Official Receiver, established under the Insolvency Act 2015 as an official receiver in insolvency. The office is a department under the Business Registration Service, a semi-autonomous government agency under the Office of the Attorney General and Department of Justice. Our governing law is the Insolvency Act 2015 and its regulations. So what we have here now is the official receiver services. So if you go to bankruptcy, then it takes you through what is bankruptcy, where a bankruptcy petition to the official receiver for the following action shall be taken, where bankruptcy order is issued, list of undischarged bankruptcies. You can go to liquidation. So I'm rushing through it because now this is on the portal. So this is public information. So this is the public information that they give, and it's very clear. Actually, everything I've seen on BRS is particularly important. Everything on this thing, because now there's a lot of things. so much under this. So then I would like again to go to, so there are certain forms. So when you come to here, you come to services. So these are the 4 registries we are talking about. The company's registry, official receiver in insolvency. These one are what we are tackling. Then we have MPSR, e-collateral. MPSR niko na title deed. Saa zizi no, not title deed. Niko na maybe logbook, nataka kusema logbook ya gari. Niko na chassis numbers za maybe for example ni machines za factory, maybe niko na kisiagi mahali, kisiagi natengeneza unga vizuri, so nataka nitumie the number ya hii machine ya kisiagi, the chassis number kwenda kwa apply law. You can use that, by the way. Maybe uko na kisiagi mahali, so that's what it means, by the way. And then we have the hire purchase registry. So hire purchase kidogo hivi sijaguza vizuri, but I'll take my time. And the 3 registries, I'm sure that I can be able to take us through. Actually MPSR is hata 30 minutes ni mingi, hata 15 minutes. MPSR ni kadogo sana. MPSR chenye nachanganya watu ni kusoma the app. Ukishapitia the app ukaielewa, ukisharudi hapa una relate everything na unamalizia MPSR hapo, because MPSR is not complicated. It's about charges. Ni kama kucharge, charge and discharge. Loan, si ukiwa loan una charge, ukilipa loan una discharge. That's it. That's all about MPSR. So hiyo tutaipitia at some point. So then kuna official receiver. So hapa kuna forms. So this is a part nilikuwa nataka tupitie very fast, and then I go back now to the portal itself. Tuingie kwa portal tuone venye ina operate, but be aware that BRS portal imekuwa developed last year 2024 hapo. Hii portal wana develop hata size as we talk. Hii portal bado iko under development. So hizi vitu zenye ziko kami ni vitu zenye ile time maybe for example we are now advocates, maybe by 2028 January hizi vitu ndio sasa watakuwa wanamalizia. So it will be like the first kind of generation of advocates kufanya this online filing ya BRS. Sasa 100% that everything is online, because as at now even some things are still offline. There are some things that ukiangalia kwa portal unaona hapana, inabidi umeandika an official letter to the register of companies, then wana receive huko, ama unaiandika through my portal, but there's a lot of uncertainty, but I'm sure they are solving it because they've been doing a good job anyway. So kuna forms. So for example a statutory demand. Let's see what this form is about. So I want to open a very few number of forms. Kidogo tu kadhaa, because there are so many forms. So for example, I wanted to open this one. So for example, there's this form is pursuant to, I hope you can see the screen I'm sharing. This is form number 1. You una download hapo kwa hiyo portal hapo penye nimekuonyesha forms ziko. So in regulation 12, pursuant to regulation 12 subsection 1. Unaona? I think for example, please guide me. How do we read regulations? It is regulation 12, then sub.
Yes.
Is that it?
Yes, you use the regulation number.
Yes. Now what you have to know, all these forms zenye mnaona hapa, nataka sasa nirudi kwa hiyo. Okay, wacha tupitie tu hii very fast. So una apply for insolvency practitioner license, and you should know that there are only 26 registered insolvency practitioners in Kenya. 26 only. Personal information, full name, etc, practicing details. Then unakuja tu kujaza these forms. Unajaza address of your office, what kind of your firm is, name of firm, partnership company for which you work, blah blah blah, whatever, your job descriptions, you do mambo mingi. Kuna sponsors, mbona unafanya hii kazi, as in a lot of questions. Have you been subject to disqualification relating to company? Unajua sasa lazima pia wadikani kama contravene provisions of the Companies Act 2012. No. They have to be that proactive. So I was just sharing that one form peke yake niwaonyeshe that hizi vitu zote zenye tunaenda kuangalia kwa act zote ziko hapa, all these forms. Unaona sasa, let me share another tab here. So all these forms unaona hapa, form 6, form 22, sijui what, all these pages unaona kuna page 1 na page 2. All these forms na hizi ni insolvency, hizi zote, all these forms they are derived from the act and the regulations. Hizi zote, everything in the act and regulations sasa iko na a standard template of how you apply for it, si ndio? So ukishaenda kwa the act and the regulations, you've read, you have gone through the act, so there were 8 pages of the Insolvency Act and the regulations, and then after you've done all that, you have to know that now the application that you're going to make already has a template form for you to fill, because now lazima kukuwa na standardization, because now if we left it up to every other advocate, tungekuja na victim watime kama wangapi. So that's the reason actually nimepata kuna hii standardization ya what documents you can find. Now the standard format zote ziko hapa. So that was insolvency. Then we have the forms for bankruptcy. There's something else I want to point out. So yes, tulifanya insolvency in LLB, we were told that now we have done away with bankruptcy because now we call it insolvency, and now the word bankruptcy we've done away with it. It's not the Bankruptcy Act no more, it's the Insolvency Act. No. But you have to know the reason why we came up with insolvency, the word insolvency, it's because now maneno ya hii maneno ya bankruptcy, it stops being about individuals alone, ikakuwa sasa pia for example limited liability partnerships, they can file for insolvency. So for example, when you're closing a company, you need to strike, but when you're closing a limited liability partnership or a general partnership, ama ile inaitwa liability partnership, yes, it's called a liability partnership. When you're closing because you've gone insolvent, so that the application is for insolvency. No. So that's the whole idea. So bankruptcy still remains. And why does it remain? Because now bankruptcy, it's more about the person, the natural person. Yes. And I want to go through another one only document, mnikubalishe one form peke yake, then from there tunaingia sasa kwa presentation. So we have the statutory demand. It's pursuant to regulation 53 of I'm not sharing, let me share. So now I'm sharing it. This is just form number 6, and you download hapo kwa bankruptcy forms. So it is pursuant to regulation 15.3 of the insolvency regulation, but inabidi nasema Republic of Kenya in the High Court of Kenya Insolvency Act, cause number 20 dash of 2026, let's call it that. Then we have the reference number, the name, those who are called in your T-stroke, I don't know what T-stroke stands for, but hapo ndo unaweka the parties, then dash made on 20 dash whatever, and then to AB or AB and company of dash statutory demand. Take notice within 7 days of service. Please notice to you, excluding the day of such service, you must pay to C, D of dash or his or their agent being authorized A, the sum of Kenya shillings claimed by B dash as being the amount due on a final judgment or order obtained by C against you, the prohibited thereon executed for his paid. You must secure or compound for the same sum to D dash satisfaction or the satisfaction. So you can just see it. So this is a statutory demand, and they are calling it a statutory demand because this is simply a demand letter, but now it's a demand letter in terms of insolvency backed by the Insolvency Act, backed by the insolvency regulation. So it's just another demand letter. So now, if now the registrar signs this. So for example, you as the advocate, you have won a judgment. So you could file this. Okay. Either you have won a judgment or also you have won some kind of insolvency proceedings. So you could file this. You could file this, but now the reason for presenting this is because now this is what has been prescribed by BRS, the standard format. So my other thing was on standard format. So tuko bado kwa standard formats. So we have Form 11 all the way to Form 20. Please take a look at the BRS website. Utakuja tu ku navigate kidogo kidogo. And the good thing with BRS is that any citizen of the Republic of Kenya, let me use the word resident, any resident of the Republic of Kenya, whether they are Kenyan citizen or not, they can have an account with the eCitizen, so that when you have an account with eCitizen, all this information is available to you as a resident of the Republic of Kenya. All the way to letting an appointment of administrator from 35. So those are the kind of things. So now back to PowerPoint presentation. Hold on, I had promised that we shall go into the website. So do we go first do the presentation and then we enter into the website? We go direct inside the registry itself and see how you apply, how the workflows are.
So let's start the presentation, and then now once we have gotten the content, you can
yes,
website and see the practical aspect.
Okay. There we are.
And then a disclaimer, Ingera, before you go to the website, remember the meeting is recorded. So in case of any privacy, you can tell me to stop.
Okay. I will do a general one. So there's no requirement of privacy for this one. There's no requirement of maybe editing something or something. We are going to show you this. Yes.
Okay, so.
Yes. And why I stressed about insolvency practitioners being only 26, I was shocked to find that so the firm I'm in right now, it's an audit firm and it's a big one. But now the issue is kwa hiyo firm, I don't think kuna insolvency practitioner mahali. Hakuna, there's no one. Na insolvency practitioners, anyone can be an insolvency practitioner as long as you're a member of a professional body. So for example, you're a member of the Society of Kenya, you're a member of ICPSK, that is Institute of Certified Public Secretaries of Kenya, you are a member of ERCPA, you're a member of forensics, you're a member of human resource professionals, hizo zote. But I found it hakuna. And it's a big one. So mimi nashangaa wa 26 kwani wako wapi? Okay. Story for another day. So 8103 insolvency procedures in Kenya. So kuna the foundations of insolvency law, objects, practitioners, offshore receiver. So hapa ndo tunapata now how can you become an insolvency practitioner? How can you become
sharing your screen, the screen for
the the presentation. Yes, let me do that. Tuko hapo. Then we have part 2 on personal bankruptcy, credit and debtor applications, trustee discharge, alternatives to bankruptcy, voluntary arrangements, no asset procedure and SIO. Then we have corporate liquidation. We have MVL, CVL, court liquidation, the 8-step BRS process. We shall go through it. So we shall see what MVL is and court. This CVL, court liquidation. We have the process there. Corporate alternatives. We have administration. We have CVA. We have insolvency, moratoriums, and then financial institution insolvency. So that's again another thing. Please remind me to show you why there is a distinction between financial institutions and other organizations. So yes, tuko na kampuni, so for example, we have the 4 types of companies. We have companies limited by shares, We have companies limited by guarantee, so that now the shareholders guarantee that now there is no shareholding, but I guarantee that I will be liable to the extent of my percentage in guarantee. Then we have unlimited companies. Those are unlimited. They're unlimited to nothing. So then we have the public companies. But now, after you have all these 4 types of companies, you also have regulated companies and non-regulated companies, or regulated institutions and non-regulated. For regulated, it means that they deal in financial management. So if you're a SACCO, if you're a bank, if you're a housing finance corporation kama HFC, if you're some kind of pension scheme, you have to be regulated. If you're some kind of payment system, so for example, hii pesa flow yenye naambiwa wanaiba pesa ya e-Citizen, pesa flow is a regulated business, unaona. But now we have unregulated businesses. Unregulated businesses ni hizi za kawaida sasa. Sijui unasikia inaitwa hardware, so hardware, so unasikia Ringera and Sons Hardware Limited, hizo they're not regulated. That's why we have that financial institution insolvency. Inakuwa differentiated juu ya hiyo. It's another whole case scenario that ulikuwa na handle pesa. It's another whole thing. So we have part 1, the legislative framework. So we stated the 6 statutes that we are relying on. That is the Insolvency Act. There is the primary statute for personal bankruptcy, corporate liquidation, administration, CBA, pre-insolvency moratorium, and then we have the insolvency regulations. So we have the prescribed forms, and this is what I was stressing on. Hizo forms zenye nimetoka kuonyesha kwa BRS zinatokana na hii regulation. So hizo forms zote, each and every form ina rely on a certain provision of the regulations, the thresholds, timelines, and the procedural requirements under the act. So the good thing with BRS, when you go ahead to ensure that that standardization, that these forms are standard, they are system generated. So it's not upon you now to go and determine. So kama ni regulation 1, rule 1 or sub regulation 1, then what's the standard form that I should use? You unaenda tu na download. There's a standard form for that. For all the procedural requirements under the act. Because now, after now we have the substantive, there is the insolvency act. We have the regulations, that is the procedural. Now we have the actual form that you file. Then we have the banking act, specialist liquidation and administration regime for licensed banks. Section 35, we have liquidation. Section 35B, we have administration. Then we have KDC, that is Act 2012, receivership and liquidation of deposit-taking institutions, deposit protection up to 500,000. And then we have the official receiver. So objects of the act about now also insolvency practitioners, IP and BRS. So objects of section 3 of the act, that is to orderly maintain orderly administration of insolvent estates, maximize returns to creditors, rehabilitation of insolvent individuals, balance interest of debtors and creditors, establish a practitioner framework. That is section 3. Then we have section 4 to 11. Please refer to the act. Must be authorized by the official receiver, that is the insolvency practitioners. Then we have the roles. We have the trustee, liquidator, administrator, and supervisor and monitor. And actors acting without authorization, that is an offense. The acts are void under section 5 of the act. Then the office of the official receiver under BRS, because now the office of the official receiver is now an internal department in the business registration service, and that's why actually they did away with the previous register of companies. Because now the register of companies was not only encompassing, it could limit itself to various kinds of businesses or organizations. And I also feel as that now Badina leave out some kinds of businesses and organizations, because tell me why we have a business registration service and we also have a society's registration service, We also have a non-governmental organizations registration service. I think they should all be under one umbrella so that now it will prevent a lot of bureaucracy in different departments. Because ukiingia kwa BRS everything kuhusu companies iko hapa, but kama ni society then you have to go in person to the office of sijui societies registrar, something like that, which is very hectic and a lot of. You should just come online to one platform and then we can do away with it. Then we have, that is now the office of the business registration service. They are an officer. They nominate bankruptcy trustees, convenes first directors meeting. You remember that? And they maintain public register of bankrupts. And this is public information. You can download this information. That is the public register. You can download it. And then we have primary decision maker for SIO and no asset procedure.
What's SIO in full?
So SIO in full is a minute. Standard, what is it called? Standard? Inanipotea sahi nilikuwa hapa. A minute, let me get to that kindly. Nimeiweka hapo but imenipotea kidogo. Itanirudia tu sahihi.
Okay.
Yes. Then you have the two routes into bankruptcy. You have the creditor's application, then you have the debtor's application. The two are under they're still under the Act. In the Act, Section 17 to 24 creditors application, and the debtor's application, Section 32 to 35. So for the creditors application, the debt must be greater or equal to the prescribed bankruptcy level. The liquid. So we should see also the bankruptcy level as prescribed. It was something like not a minimum of not at least a minimum of 100,000 and not more than 4 million, something like that. Then we have the liquidated and secured immediately due. Then statutory demand served after 21 days have lapsed. Then execution. So the statutory demand to the owner. We have the execution returned partially unsatisfied. So that is where now ulituma auctioneers walienda wakarudi. Is it returned wholly or partially unsatisfied? Unaona. Then you have the no outstanding application to set aside demand. Then we have expedited application available if risk of concealment, Section 19. Then secured creditor may apply willing to surrender security or for unsecured portion only. So for the sole ground of the debtor's application, that is the inability to pay debts, Section 32(1). And we saw that a bankrupt, I don't know if I mentioned this, but a bankrupt is or just the point where now you have any application for bankruptcy. It's where now the person in question or the party in question, they are unable to pay their debts as they fall due. Then we have the other test. So kumbuka tuliambiwa kuna two tests. Kuna cash flow test, si ndio? Na kuna hii bankruptcy test. I don't know. Ama nimejirudia kindly? Maybe someone confirm.
No, you are on track.
Yes, cash flow test. That is now the balance sheet. Wanaenda kwa vitabu zenu. Wana peruse your financial statements for the last 3 years. Wanaona what you've been doing here. Wanaona hapana. We need to wind up this thing before ikue a disaster. So unakumbuka that's the reason why kuna ile yenye tulifunza kwa capital markets and institutions. There was that Enron scandal that the administration of the company wanajua hii biashara yini mahali but wanaendelea tu kudanganya. So that's why actually pia hizi vitu kama hizi ziliwekwa. So then now you audit for 2 years, na una realize after 2 years audit when the books zinaenda, that means you have to close immediately before you cause any further damage to any creditors or something. Then the documents required by BRS. So form 10 is bankruptcy petition. Zile forms zenye tuliona kutoka BRS. Then we have a supporting affidavit. Form 8, you have an application for bankruptcy trustee. You have a statement of affairs. Then the statutory payment to, so that is now debtor's application. whether you're a company, whether you're a natural person. Kama unataka kuanzishwa hii process, the first hii ni kama retainer, this statutory payment is a retainer to official receiver, 30k. For your process to start, you have to pay that 30k. Then the court satisfies, then you have a hearing, and then you have a bankruptcy order made, and then now after bankruptcy order is made, you are entered into the list of undischarged bankrupts, and the story continues. So we'll see it. So now here we are. Effect of the bankruptcy order. SIO. Bado inanikujia inanipotea kidogo, nitakumbuka pesa hizi. Effect of the bankruptcy order. Yes, there is a hand up or something.
Not a hand up.
Yes.
We posted the difference between cash flow test and balance sheet test in the chat box. That cash flow test asks whether the debtor or company can pay debts as they fall due, a liquidity test, while balance sheet test asks whether the value of assets is less than the liabilities, including contingent prospective liabilities, or in short, this is what we call a net worth test. Yeah.
Thank you very much. Thank you very much, Victor, for that. So as we're going on, so we can go on. What happens the moment after the order is made? That is section 48 of the Bankruptcy of the Insolvency Act. The debt recovery stays, so all proceedings to recover the bankrupt's debts are stayed immediately. The official receiver publishes, they publish in the Gazette, and of course a newspaper of circulation within 30 days of the order, section 48.3. Then we have the first creditors meeting. Official receiver convenes within 14 days of notices unless no request is received, section 52. And there is actually a form for this. Ukienda huko kwa hizo forms tulipitia, is a form that you fill for you to have a creditors meeting. Then the property vests in the trustee. All property and powers accessible for own benefit vested in the bankruptcy trustee. So the official receiver anakuwa yendo ni kama amekuwa an interim shareholder, ni kama amekuwa interim executor. Thank you, the word is executor. Anachukua everything, anaanza sasa ku go through, and of course you remember there is a hierarchy. You have to service the you have to service the secured creditors. There is a certain sort of order that you have to meet. So I will also give an overview of that. Then you have the statement of position. The bankrupt must lodge statement of financial position with the trustee. Then we have the trustee who is appointed. The official receiver nominates creditors may appoint licensed practitioner. That is per section 44 and 59. And now the official receiver and the trustee, now they are now the Nikama executors, because now what you has your properties have become like an estate. So Nikama you are in some sort of estate administration. Yes, now the bankruptcy trustees power and distribution per section 63. Powers of the bankruptcy trustee is manage and realize bankrupt's estate, carry on the bankrupt's business for benefit of creditors. So if there is some ongoing business that needs to be done before we close, for example, there are some creditors that have not been cleared, you're not cleared with KRA, you're not cleared with the register of companies, so you have to get that going. Then you have the bank money and invest surplus funds, assign right to sue under the Act. Now now that they have become the executor, they have to take up the company or the organization as an ongoing business until they close it. So the moment they take it up, they have to ensure that the business that is required to be done in regards to having now this organization or the business ready for the dissolution. Let me use the word dissolution. Then or distribution. So that's another thing. So they need to ensure that this business is ongoing the minute they take up that organization or the business. And then they summon bankrupt for examination before court. They make distributions per the second schedule. They keep proper accounting records. So they continue with everything as it should be done. Produce financial statements of receipts and payments, section 73. Then the distribution, that is the second schedule priority. So the distribution is costs and expenses of bankruptcy. Then you have preferential debts, that is wages, that is now salaries to your to your employees. Then you have the taxes, then you have such as NSSF and the EKASHA hapo with the new government's EKASHA, EKA housing, as in if it is something that is required by the government to be paid as a statutory levy, hiyo uweke hapo yote because they are preferential. The word is preferential. Then you have ordinary and secured debts. So they rank in pari passu. So all the ordinary debts unsecured, you have to ensure that by pari passu we mean that if for example ulikuwa na mmoja ulikuwa na 10,000, you are owing another 12,000, another 18,000, you have to ensure that you pay them equitably. Hizi lipa ule wa 18 then wache huyo wa 10 na 12 kama hawajapata kitu. You have to ensure that they are equitable to their debt percentage. So kama pesa haitoshi, then unawalipa a certain proportion of their debt percentage. And then you have interest accruing after bankruptcy order. You have the deferred debts, then you have the surplus amount now that is returned to the bankrupt. So now this is the hierarchy in tulikuwa tunaangalia. And something you have to know, the preferential debts, hapo ongeza pia the secured debtors. Because preferential, by preferential we mean that a priority is taken. A priority is taken for these persons. There's a priority taken. So yes.
So let's take you back before you proceed.
Yes.
So this deferred debts, maybe you can go back to the previous slide.
Okay, a minute. And that has actually quite reminded me about the SIO. So now it has come back to me very vividly. So a summary in installment order. So I am a bankrupt, senior. But I don't want to go under no asset procedure because now no asset procedure says that the moment now I'm an discharged bankrupt, then inakuwa that I have to be discharged kwanza. Ndio sasa I go back to conducting business. But remember the summary installment order is where now I go to pledge that now I agree that I have debts that have been overdue. I am unable to pay these debts as they fall due. But we can make an agreement for a certain set of payment in installments that if I undertake the payment in installments as I promised, then by the end of this summary installment order, I will have completed the payment of all my debts. So a summary installment order, it's a good one because the first thing is that I don't think it reflects in the list of, it does not reflect in the list of discharged or undischarged bankrupts. Because here you have to show that you have some income. So if you have some income in inakuja, but hii income inakuja at a certain rate yenye haiwezi service all these debts, but if I took an agreement to service the debts in installments, then I can be able to do it either in full or to some extent as practicable. Acha nitumie the word practical, then pia inakubalika. So that one will make it to the office of the official receiver, because ukiongelea maneno ya no asset procedure, ukiongelea maneno ya the insolvency itself, the bankruptcy order itself, hizo zote ni kotini. So I can choose to not go to court and go to BRS, niende tuanze kudeal na the official receiver. So that's the distinction now.
Oh, yes. Thank you.
So tunarudi.
Yeah, nataka kuuliza those are deferred debts. Also, I didn't understand what you meant by pari passu, the ordinary and secured debts vizuri.
Okay. So we have secured debts, we have unsecured debts, and then we have deferred debts. So let me take each as it is. But for deferred debts, nataka nianze nayo. So remember what we have done in LLB about debentures, about simple. So for example, there are certain kinds of debentures zenye nimeona kwa commercial transactions. So there is one certain one that unaweza taka kutumia. So there is something called a simple agreement for future equity, a safe note. So a simple agreement for future equity, SAFE, is where, for example, I'm the shareholder in a company, then I do not have enough capital in this company to run the company, but I do need capital, and at the same time, I would not wish to acquire capital in terms of a loan. Then I take on a debt that is to be paid at a future date, or that debt and its terms of maybe repayment, terms of interest will be determined at a future date. So for example, you give me 100k, but tunaambiana umenipea 100k today 5th of April 2026, but the time when we talk about this debt and how much I owe you and how much interest was earned or accrued, it will be on the 1st of August 2026. So that's what a deferred debt is. Yes, nimechukua do, but it's not a debt that imeanza kuhesabu sahi ati sasa interest imeanza kuhesabu. The loan has started, so for example, if it is due in 6 months, then from the date of today umenipatia loan, then in 6 months I should repay you. No, then that is deferred a certain date in future. So those are all about deferred debts. Na ukiangalia hizi deferred debts, unaangalia pia kuhusu, there are some explanations that zimefanya kwa commercial law, but I don't want to go back into that. No, let me not mix that. Let me not mix that. I would like to go back to unsecured debts, and then when I'm done with unsecured debts and then secured, then you can tell me whether we have at least covered what these deferred debts are. So unsecured debts, they rank in pari passu. So what are unsecured debts? So the difference between an unsecured debt, unsecured debts and secured debts, these are the preferential, is that the preferential or secured, they are backed by contract. So for example, for salaries and wages, that is backed by a contract with the employees. For taxes, that is backed by the fact that you are a registered organization with the government, so you have to pay taxes. NSSF, still the same way, you owe the government. If it is NHIF, SHA, you still owe the government. If it is a bank, then you owe the bank because it's a secured debt, because it is backed by a contract. Tulikupea loan, it is under this account. Hii pesa ile move from hapa to hapa, and from the date it move, then tunaanza kuhesabu hii debt. Then the other thing is, if it is a circle, if it is a financial institution, if it is a capital market organization, because now those are different. Hizo za huko securities nini. So for example, kwa Central Depository Settlement Corporation, kwa CDS accounts, hizo za capital markets. For example, the Nairobi Securities Exchange, you participated in a sale or in a purchase of securities, but those securities were purchased on a credit note. No. So yote kuna contracts, they are backed by statute, they are backed by contract. But when you go now to ordinary unsecured debts, the reason why these rank in pari passu, first of all, these unsecured debts is where you as the business, you acquire these debts in terms of, so for example, ni biashara ya hardware ya simiti. So instead of me going to the bank to get a secured loan for 1 million Kenya shillings so that I go buy cement to sell, I go to a distributor for cement. So for example, mimi am a retail hardware. Nenda na buy cement, nenda nachukua cement worth 1 million from a distributor. This is unsecured because he buy on credit. This is not a contract. This is in the conduct of business. These are debt accrued in the conduct of business itself. Hii hatukwenda kutumia jina ya kampuni kunini, hapana, kuchukua loan. Hii si loan tulichukua the commodities. We went maybe sold them, but we were not maybe able to send back their 1 million Kenya shillings. So by the time tunafanyiwa bankruptcy, then we are required also, we owe that person. So this is na rank in pari passu. Ndio sasa The moment to feel the cost and expenses of bankruptcy, pesa ikabaki, we take that money to preferential debt, secured debt, creditors, whatnot. Then the third thing we do is we distribute the money to ordinary and secured debts kama suppliers, kama I think I want to use suppliers as the best example hapo. Then we tuende kwa interest accruing after the bankruptcy order, then deferred debt. Then if there is any amount sasa ndio inakuja kwa bankrupt. So what does that mean? That means that hata pesa inaweza ishia hapa kwa cost and expenses of bankruptcy. Point 1. That pesa yenye imebaki ikishafanya cost and expenses of bankruptcy, then that's it. Kampuni imeisha. Unaona? And that's why there is a hierarchy. Hapo kwa second schedule of the Insolvency Act. Let's ensure that we also do more research on that. Yes.
Ringera, before tutoke kwa hierarchy. Yes. CLE iko na habit ya kuleta a situation yenye iko na all those people in one question. So what I did, nimeweka kwa chat box the required order from top to number 7. So I can take you through to mbio. I realized from your presentation kuna zenye zimeruka kidogo but slightly. For instance, the number 1 ukiona kwa swali, realization of cost and liquidation expenses including liquidators property in card. Ungetoa slide juu, natumia chat box.
Sorry.
Bado ungeendelea tu kupresent hapo kwa chat box. Realization cost and liquidation expenses including liquidators property in card cost ama remuneration, court can direct priority. So in case CLE ikulete liquidator hajalipwa, that is number 1 thing to be paid. Na cost the expenses zenye zina run from that process. Number 2, secured creditors. Hizi wanalipo from au ni wenye sasa maybe wameweka fixed charges, mortgages ama wamepledge. They are paid from their collateral. Any shortfall becomes unsecured unless otherwise secured or guaranteed. So unapata secured creditors ni wenye maybe walikuwa wameweka fixed charge over their property. Sasa unapata when it comes to the company is going under, these are number 2 in priority. Sasa kama hiyo other debts zao zenye wameandikiwa hapo haziko secured by that collateral ama zina supersede, ziko excess of the collateral amount, the other amount will not be secured. So hiyo utairusha kando, utasema this is unsecured debt, we only stick to the collateral value yenye tuliingia into.
Number 3, addition to that filter, addition to secured creditor, for you to be a secured creditor, you have to be kama hamkuenda process ya MPSR ukakuwa entered kwa MPSR. Ndio sasa ukishamaliza maneno ya MPSR, the moment that notice has been approved, ukigenerate official search ya hiyo kampuni ama that business, it has to show their encumbrances. Nitashare one kind of CR12 iko na encumbrances. Tuone sasa kwenye hizo if your debts haziko listed hapo as a secured creditor, then you do not fall under secured creditors. Sijui mbona nataka ku stress on that. For you to be a secured creditor, lazima uli go through MPSR. Uli register your debt with the business kwa MPSR, mkaenda wewe na the businessman, mkaambiana ama the business company ama whatever the organization, mkaambiana now I want to register. Hata kama nimekupea deni nataka ikuwe registered because the debt insolvency, this is where they look, the official company search, the official business search. Hapo ndo wanaangalia. Please continue, Victor.
But Ringera, on that point ya MPSR, let's say ni fixed charge over land property, yenye unajua ifall under MPSR. So hapo lazima tukubali there will be an allowance.
PAO, because if it is a fixed charge, then it is registered in simpler umbrella. Sasa tengeneza an umbrella, it has to be registered whether under MPSR. If it is a fixed property ama hiyo real assets, if it is a real asset kama land, then a charge was registered by that bank na iko kwa title deed. Kumbuka kwa title deed tulisema aje, every title deed the moment umeregister a charge, hiyo charge lazima iwekwe hapo kwa hiyo title deed ndio uendelee cooperate na title deed ya shamba yako. Yes, you have to produce all those, na hizo zote lazima ziwekwe kwa meza. Everything that company use italetwa hapa. Kama ni title deed inaonyesha kwa charges, kama ni kwa kampuni mmecharge under the company's assets, iko kwa CR12, the official company search. Yes, Sasa hiyo ndio part ya section 2. Ndio sasa we differentiate from the preferential debts hiyo venye Victor anaendelea. These preferential then unsecured. So nimeona penye
Thank you. Sasa unaona hapo pia mimi nimesaidia clarification na wewe umetusaidia pia by the practice side, tumeelewa sasa the difference between the two. Sasa number 3 in the list ni preferential debts. These are paid from the free assets and in certain cases may rank ahead of floating charge claims per the act. So preferential debts zenye Ringera amesema, if you don't register the caution, if you don't register the interest by MPSR kama ina fall under MPSR, then itakuwa a free asset. In my view, that's what Ringera amesema. Then remember pa kuna rider that it may rank ahead of floating charge claims as per the act. Alafu we look at number 4 ni floating charge holders. From assets subject to the floating charge after statutory prior claims or expenses that outrank the floating charge. So hapo I believe iko straightforward juu unatoka preferential alafu unaingia floating charge holders. Am I audible? Hello? Hello? Yes. Morning. Niliko hata kwa webinar na present, maybe after presentation. Haitakaa sana, around 10, 11. Okay. Okay.
Hello.
Okay.
Hello, Victor.
Oh, yes.
Hello.
Oh, good.
Hello, Victor. Your network is breaking a bit.
Oh, a series, a technical problem. Good. Yes.
Maybe Ringera and Victor solves his network issues. Could you remind me what floating charges are?
You are undertaking now. Nice one. Interest and 5. Okay. By June, acha tuweke by June.
Ringera?
Okay, mimi naendelea kuongea bila microphone nimefunga. Okay. So we have the floating charge na kuna hizi charge zingine ziko kwa secured creditors. But what you have to remember is hakuna mtu atakupea do as a loan kama mna agreement or something.
Yes.
But this is where we differentiate the two agreements. So let's say I have 1 acre of land.
Okay. Hello guys, am I audible? Hello? Yeah. Hello? Hello, am I audible? Hello? Hello, am I audible? Yeah.
Institution or a person.
Hello.
Mwenye atanipea pesa but hii pesa amenipea iko only charged under a specific asset or a specific workflow in my business. Unaona? So what I mean is in my business then this floating charge to execute the agreement with the person who gave me the money, and this money is going to ensure that after tumeproduce unga kwa hii kisiagi, because kisiagi ndio tumecharge, but after hii kisiagi imeproduce unga, then hii pesa yenye nimepewa sasa ni ya kucontribute to now distribution of the products from my company. So it's charged on a specific either an asset or a certain workflow, because service, look at the word service, because you can charge even a service. Yes. So, but this one is a person is an agreement between the business and the creditor, and most likely they are not registered, but you can register them, and then when you register them, they become secured creditors. But these ones, they are not registered, but they still stand, because now if these people go claim now after the first hierarchy is done, the second hierarchy is done, then these people can claim for their money, and they're in the third hierarchy. So that's a bit about what we have.
JJ, I'm back. Nilikuwa nimepigiwa na bosi.
Okay.
Sasa ikakata network. Now, tulikuwa tumefika wapi? Secured tumesema. So naweza rudia tu juju. Expenses incurring from that process ama liquidated charges. Secured creditors tumeongelea. Then kutakuwa na preferential debts. Alafu floating charge inakuja chini ya preferential debts. Then we have said that unsecured creditors ina run pari passu as per rates venye you'll explain after preferential debts, then post liquidation interest only if there is a surplus, hiyo hapo ulisema vizuri. Then lastly itakuwa shareholders or members being the last any surplus after liabilities watu wame incur. So CLE niliona situation pia a shareholder alijaribu kujilipa akiwa wa kwanza, so unaulizwa the offense that was committed. So CLE has a habit of playing around this flow of various debtors. So hiyo ndo nilikuwa nataka hapo tukue tu in line with the same. Yeah, thank you. Hapo ndo nilikuwa nataka kuinsist. Now you can proceed. Nimetuma kwa chat box.
Thank you.
Ringero,
yes.
Umepotea? Oh.
Nico. So what I can say about that hierarchy as we move on, your hierarchy, it might be, yes, it is, actually let me use the word, it is followed as that hierarchy. So that's how they follow it. But in the CLE situation, you don't, for CLE, you don't have to be accurate about what is on the ground, but you have to be accurate about what the act prescribed as the hierarchy. And I think hiyo yenye Victor ameshare hapa ameshare kwa chat, then this is what the second schedule of the act provides. So if you are able to bring it out this way, then you are good. Then you have discharge from bankruptcy. So there is automatic discharge, early discharge, objections, and disabilities. So there is pursuant to section 254 of the Insolvency Act, the bankrupt gets an automatic discharge after 3 years. The bankrupt may also apply to be discharged earlier. However, bankrupt is not automatically discharged if the bankruptcy trustee or a creditor has objected to section 256 under section 256 of the Act, and the objection has not been withdrawn by the end of the 3-year period. So it's a 3-year period. That's something else we also have to remember. So I have been referring actually this information from the 6 statutes zenye nimewambia and the articles by the Business Registration Service itself. Then there is automatic discharge, section 254. It is 3 years from the date of lodging of statement of financial position, and it's not from the date of the order. That's something else you have to note. It has the same effect as a court order of discharge, section 255. You can object under section 256 to 259 of the Act. A trustee of short receiver creditor with leave may object, must follow the prescribed form. If the objection stands, then public examination and the court may discharge the discharge. So kuna form ya apply for this. There's the early discharge per section 258 of the Act. The bankrupt may apply to the court at any time. Court may be approached again before specialized date if previously it had refused. And then you have the disabilities, where a bankrupt cannot be a company director without leave of the court, cannot be a member of parliament per constitution. No, that's not constitution, it's actual. So that's a mistake there. Then they cannot practice as an advocate, section 32, and these are all lifted on the discharge of the bankrupt. So hapa kwa constitution it's where the qualifications for you to become a member of parliament, you cannot be an undischarged bankrupt. So you have to be discharged from bankruptcy to vie for any elective seat actually. So you have the alternatives to bankruptcy. You have the alternatives. So they like to refer them to as non-stigmatic routes, because now bankruptcy or the state of being bankrupt, now when you are an undischarged bankrupt, then there's a lot of stigma attached to it, because now hizo tumeziona hizo, you cannot be a company director of a company, you cannot be an MP, you cannot practice as an advocate, you cannot give any guarantee in a financial institution. Ni kama tu kuwekwa kwa CRB. Ushaiweka kwa CRB then ukajaribu kuomba loan kwa another maybe a lender. They tell you you are in the CRB, ni the same thing. Okay, sitasema ni the same thing, but something like that. There is a lot of stigma to it. So there are non-stigmatic rules, and we have SIO here. So we have the voluntary arrangement, that is VA, section 303 to 322 of the Act. The data proposes composition scheme to the creditor. So unaenda, you do your books, then you come up with a scheme, you come up with a promissory note to your creditors. Then you apply to a licensed insolvency practitioner as a supervisor. Remember that we said there are only 26 in Kenya as at now. So you apply to one to supervise these arrangement. And then you have the interim orders. They freeze the enforcement while the proposal is prepared. Then you have the creditors meeting to approve, and I have modifications or reject viewer scheme that you gave. Then you have an approval of the voluntary arrangement to bind all creditors entitled to vote. Then you fast track the voluntary arrangement available for discharge for undischarged bankrupts. So that's another thing, that when you make your own voluntary arrangement, then they ensure that the process is a bit faster. Yes, and then you have the summer, because now we have talked about this process being 3 years long. So remember, for a businessman, 3 years is such a long time. Summary installment order, that is SIO, section 323 to 342 of the Act. So official receiver will direct debtors to pay debts by installments. So they're initiated by debtor or creditor with debtor's consent. So either of the two can initiate. Then there's a debt ceiling prescribed by insolvency regulations. Then there's an application that to state that the percentage to pay per the installment amount and the supervisor of that arrangement. Then the earnings attachment available, section 340. And then there is a default. Official receiver may cancel or vary the order. So that's a power of the official receiver. So that's what the summary installment order is. So you're not yes, you're ready to have an official receiver to be the supervisor of these proceedings, but you don't want them to dictate, so you make for a summary installment order, so you are the one to make the particulars of how these accounts will be settled, because now we are talking about money. No asset procedure, the NAP, section 343 to 361, for debtors with no realizable assets. The total debts is 100,000 to 4 million. They have to be within that range, of course. Then the prior, so hapo unakuja unasema I have nothing to pay you, so I want to declare this NAP. Unaona, so you also have to have no prior bankruptcy or NAP admission. Official receiver notifies creditors. Creditors cannot enforce during the no asset procedure. The credit limit during no asset procedure is 10,000. So during this process, you can only take 10K, but I'm 100% sure that nobody will loan you money if you are under any of these proceedings. And then discharge is after 12 months from the public register under section 350. Remember now, this is for no asset procedure, that is 12 months, 1 year. But the bankruptcy itself is 3 years. You went the long route of it. So how would you be eligible for NAP? So it's the official receiver to decide. The admission criteria is under section 345 for no realizable assets. You've not previously been admitted.
Ringera, you're muted. Jabet, can you hear Ringera?
No, I can't hear him.
Ringera umepotea. Ni kama amepoteza network.
Ama amepigiwa.
Oh, yeah. In fact, an outline a very critical process. Juu nimeona amespecialize na natural persons. Juu yangu ni ya corporate. Now the 3 stage nimekuja sana nikaiweka in an easy way to understand na various sections. Yake at least anatuonesha the bankruptcy angle.
So hii procedure yote tumesema haiwezi apply kwa company.
Kampuni iko na zake.
Kampuni is talking about natural persons only.
Hizo no asset procedure sijaziona in a company unless I dig deeper, then I clarify. Juu what I have ni compulsory liquidation.
Oh, yeah.
Alafu member voluntary liquidation. Alafu kuna creditors voluntary liquidation. So hiyo angle ya no asset procedure, can a company go and say we don't have any asset? Unaona? Okay, it's something that ndaangalia. Bado siwezi sema with certainty.
Yeah, actually nimekumbuka something like that.
Sindio, inakaa zake ni za tunaona ni alternatives to bankruptcy. Bankruptcy of a person. The 3, anasema the 3 sasa. Summary installment order, no asset procedure, alafu ingine ilikuwa
Yes, so
kuna ingine
hiyo voluntary arrangement.
Pia voluntary arrangement. Unaona pia kwa kampuni kuna voluntary arrangement zake. So in fact hata akirudi, that is the question that I'll ask him. Whether the same also applies to companies, ama ni strictly for bankruptcy angle?
I think outline yake, I think the second slide, alikuwa amesema ataanza na bankruptcy and then signed mambo ya companies.
Oh, so okay.
Mm.
Hapo umesaidia. Sasa acha nimstue nione kama anarudi. Ako offline kama ni stima.
Sasa nijaribu kuproject tuendelee na discussion in the meantime.
Oh, yes. Yes, we can do that. Mali tu ameachia, we take over.
Okay, just give me a minute.
Okay.
So I have shared my screen. I think I got page 12.
Okay.
So you were saying this NASEC procedure, section 343 to 361, 343 to 361. We already discussed this bit. So we are looking at eligibility in detail. That is when you can apply for the no asset procedure. And he said the admission criteria under section 345 is you have to prove that you have no realizable assets. You also have not been previously admitted to the no asset procedure. You should not also have been previously adjudged bankrupt. And the total debts that you want to admit into this procedure should range between 100,000 to 4 million. And you have no means to repay any amount. So the disqualification grounds, when can you be disqualified from this applying for this procedure or undergoing this procedure? One, when you have concealed assets with the intent to defraud. Like, sorry, I have some kids here who like to play with me, so they're knocking on my door. I hope just give them.
Oh. Okay, yes. I can take over from you. Nikusaidie?
Yes, unaweza take over kidogo. Sasa narudi, nitaka kuambia waende wakae kwa nyumba kidogo alafu nitawaita baadaye.
Oh, sawa. So as Jebet you are presenting, then if you go to the disqualification grounds provided under section 346, it says that concealed assets with intent to defraud, the same procedure can be declined. While you are conducting or constituting an offense when you are bankrupt, that process can be declined. When you are incurring debts knowing that you are unable to repay them, that will also be a ground for disqualification. And then when a creditor is likely to achieve better outcome via bankruptcy, then this process will be disqualified from your end. So there is a process and defects that Ringera had tried to project. If you look at number 1, the debtor lodges an application plus statement of financial position with the official receiver, pursuant to section 344. 2, the debtor may also notify all known creditors of assets and liabilities, summary, pursuant to section 347, or the debtor may send admission notice to debtor. Hapo sijaelewa. Send admission notice to debtor, NAP commences. Ama ni to creditors. I believe hapo alimaanisha to creditors. Creditors may not enforce debts during NAP process. Debtors' duties must not incur credit above 10,000 without disclosure. Automatic discharge after 12 months.
Victor, you
Yes.
see this or you are reading, it's the official
Yes.
receiver. So you see the official receiver now sends the admission notice to the debtor. Now no asset procedure commences. The official receiver also notifies all non-creditors on assets. Summary. And then the creditors may not enforce the debts during the non-asset procedure. The debtor's duty must not incur credit. No. Usually when you say you cannot, if you're already a debtor, under this procedure, you cannot take up a loan more than 10,000.
Yes, I remember.
Particularly without disclosure, and then you will be automatically discharged after 12 months, where the public will then be updated.
So that's why that is the reason why he told us to go under no asset procedures compared to the normal bankruptcy procedure that is lengthy and costly.
Yeah, he said because it's just agreements that you enter into. For example, also the voluntary arrangement, even the summary installment order. I think it offers a bit more flexibility on the part of the debtor.
Thank you, Jabet. But before you go to corporate liquidation, there are some key things I want to confirm, not from this slide, the previous slide now, the one that has listed the 3 processes. I want to be able to just identify that this is a summary installment order procedure, these are no asset procedure, these are voluntary arrangement procedure. Now, ikuje naturally. It's like I'm not supposed to go back to this slide so that I can confirm whether I knew them. I just want a clarification on these 3 as per the shared slides. But Ringera is back. Ringera. Jebet, you can take it, then Ringera will go second.
Yeah. So that you can differentiate them. First, the no asset procedure, you have to know that this is when you actually have no realizable asset. So and then it also provides a limit to the debt. So if your debts are more than 4 million, you cannot enter into this no asset procedure. So that is how you can differentiate the no asset procedure from the voluntary arrangement and this SIO. And then now under the voluntary arrangement, you as the debtor, you propose the scheme to which you're going to pay. For example, tell your creditors, look, I know you owe me, let's say 5 million. I'm going to pay you, let's say 250,000 for this particular period of time. And then now you also have to take that idea to the creditors during their meeting, and they have to approve or disapprove of it. And if they disapprove of that proposition, you can include modifications as per what they decide on. So after you include the modification, perhaps take it back to them again, and then once they approve that voluntary arrangement, it now binds all the creditors and also you yourself as the debtor. And then now in this SIO, which is the summary installment order, it's the official receiver who directs you as the debtor to pay your debts by installments. So it can be initiated by you as the debtor or by a creditor with now the debtor's consent. So the creditor can come and say, okay, I think you should pay my debts in installment. Do you agree by this and this and this? Or you as the debtor yourself can initiate it. So I have not gotten any other clear difference between SIO and VA because they seem more or less the same to me. Maybe Ringera can take up from there. So I'm going to stop sharing my screen, and then Ringera can begin from that. Just try to differentiate between the VA and SIO.
Thank you, Jebet.
So, and we're going to end off for a minute. So, the voluntary arrangement. So, the debtor makes a kind of a proposal to the creditors. It's a scheme to the creditors. And when we talk about a scheme, a scheme can also include additional credit. So, for example, I owe my creditors 6 million Kenya shillings, but the reason why I owe them 6 million is because, but back to my example, niko na kampuni ya kisiagi. Sisi hutengeneza unga ya wheat, maize flour, any kind of unga. So kuna a 6 million tulichukua, then hii 6 million again tulichukua ndo tununue kisiagi ya kusiaga unga, but sasa tuko na the capacity ya kusiaga unga, but we don't have the capacity to distribute hii unga. So unakuja nawaambia okay, na kama uelewe hivi, yes, we have been unable to do business because we have been unable to generate revenue. So that means that we have been unable to pay our debts to you for ile kisiagi. And why? It's not that the business we started is extinguished. No, it could be that the business cannot be completed with that amount of money as is. So he's making a scheme, a proposal. So it can also be a business arrangement. That was what I was trying to say. So for the voluntary arrangement, it's only the debtor who makes this application. You see, it's only the debtor who can make it. The debtor now anaenda kwa biashara yake, anaangalia the business model, anaangalia if it can twist and turn my business model this way. That means that hata kama saizi niko kwa shida ya credit and I can be discharged as a bankrupt and such, I can also take on a proposal with my creditor, waniongezee pesa ama wa reduce the interest rate ama a scheme, an agreement which is in the form of what we talk about a debenture. A debenture is where is more like an IOU. Ni kama unaambia your creditors, una issue a new promissory note that I know my business has not been good and I know I've not been generating revenue, but as things take a turn in the next one financial year, nataka mnipe maybe some time to organize my business in this particular manner, so that if all the creditors agree with your business proposal, because now this is a business proposal, it's more like a business proposal, and that's why we say that you cannot extinguish or get into insolvency without having a case scenario. And I pray that as I'm doing my research, nitapatana na one good case scenario so that we can do one specific one from the start to the end, then we can see how this applies. But now, in practice, this can also be a business arrangement. Unaona? This one can you can twist this undischarged bankruptcy to you being forgiven by your creditors, to you being discharged as a bankrupt, yet you have not paid your loans. Yes, yet you have not paid your loans, and at the same time you continue in business with your creditors. So bankruptcy is still a business transaction. So we need to also think about it in the manner of business. So back to a summary installment order. A summary installment order, hapo kuji kuwapea story kama voluntary arrangement. Hapa si story. Hapa unawaambia the topic in issue is only one. How am I going to repay your money? So I could repay it in installments. So because now I can't pay it in full as at now, ndio tukakuja tukasema the application must state the percentage to the installment amount, and the supervisor, that is the IP, the official receiver or the IP, who is in charge of this under section 323 and 342. So hiyo ndio unaweza itwist hivyo. Yes.
Thank you, Ringera. Now it is very clear.
Yes.
You can proceed.
So we were at no asset procedure before I disappeared. We were at the admission criteria under 345, section 345. So there is no realizable assets, not previously admitted to NAP, not previously adjudged bankrupt. Total debts is, there is that limit. No means to repay any amount. The disqualification 346, concealed assets with intent to defraud, conduct constituting an offensive bankrupt, incurred debts knowing and unable to repay, and the creditor likely to achieve better outcome via bankruptcy. This is the process and effects. So the debtor lodges application plus statement of financial position with official receiver. So hizi ni books zako, balance sheets for the past like 3 years. Hapa wakikwambia financial position, it's not like you just bring in it's last year ndio umeshindwa. Hapana, they might even ask for the 10 years books. They want to see what your business has been doing. So you know the government huku ndani ndio watakuja waone pia taxes huku unalipa. Kama ulipi creditors wako na taxes ulikuwa unalipa kweli? So even in insolvency there is a lot to it. There is a lot to commercial transactions, a lot. Kwanza serikali ukiingiza hapo, there is a lot to it. So you load the application, the official receiver notifies all creditors of assets and liabilities. There is a summary now that is now drafted, and now hii notification ni wana draft a summary, but wanasema if anybody has an objection to this list being to continue as is, that is now, if anybody has something to add to this list, please come with proof. See, it's not even Kenya Gazette kuwa. Kenya Gazette, anything that is posted is a notice for the general public to come and contribute. It's just a public participation forum. Yes. So that's something else. And then official receiver sends admission notice to debtor. Then the no asset procedure commences. And creditors may not enforce debts during no asset procedure. Debtors' duties must not incur credit. No one will give you money actually, but now the limit is not more than 10,000 without disclosure to the application that is already in NAP. You can't take other loans can't take credit without informing the application. Your application or NAP kuko lazima you lodge these debts. Any debts you take from there on. And then the automatic discharge after 12 months, public register is updated. So get there. So let's go on. So we have corporate liquidation. So there's 3 types. So we are there. So tulikuwa kwa bankruptcy. Now we are in insolvency. I don't want to make the distinction. There is no distinction, and actually the word is insolvency for both. But the reason why I say we were at bankruptcy, for bankruptcy is for mostly natural persons, but for insolvency it's mostly for businesses. Let me call them businesses. I won't say corporate only. There's a tendency with these statutes to refer to only corporate, that is companies. But remember, a sole proprietorship, the only reason why a sole proprietorship is not referred to as a company is because now it's not incorporated. But if you ask me at the basic minimum look, ukiangalia tu the structure of a sole proprietorship. Hiyo ni kampuni. It's just a company, just that you're trading in your individual name, but it's still a company. So me, I would like let us understand now also sole proprietorships can also go through this corporate liquidation to some extent. Na kwanza KRA ikiingilia hapo haitataka kujua nini imeandikwa kwa statute. KRA kishaingia hivi wanaenda wanatumia hii, wanapenda hii sana. Now this is part 7 of the Insolvency Act 2015. Is a threshold of 100,000 plus. Your debt can't be 99,000. You can't be a pauper and then you're already a pauper and then you want to apply for insolvency or bankruptcy. No, you have to have money. Lazima kuwa pia wewe ni mdosi. Actually hizi ni kazi, hizi ni vitu za wadosi. Sikia tu mtu kwa hizi processes ati hawa ni wadosi, hawa ndio kuna mashida kama hizi. And then liquidation is the process of winding up a business following an event of insolvency. Insolvency is defined as the inability of a company to pay its debts of 100,000 shillings or more. On appointment of a liquidator, all the powers of director cease and the affairs of the company as well as its assets are vested in the liquidator. So here the main thing, that the liquidator, that is the official receiver of the insolvency practitioner, they become the absolute director. They become the absolute director the moment liquidation begins. So we have 3 kinds. There is section 392 to 413 of the members voluntary liquidation. Then we have creditors voluntary liquidation, CVL, 414 and 440, liquidation by the court, 447 and 530. So members voluntary. So then when we finish this, then tutaingia kwa BRS for some insights, tuone kwenye hizi kwa registry ziko wapi. So hata the key thing we just to know kwa registry iko wapi. Ukishaiona hiyo, because BRS ni hiyo yenye tulisema the forms ziko standard. So unaenda una download zinakuwa signed na upload. Hakuna kitu ya kudraft mingi, hakuna draft mingi, but just know where the registry is. The registry is where the application is to be made, because sasa hii ni some sort of IT. And then members voluntary liquidation is initiated by shareholders by passing a special resolutions. So in a company there are at least there are more than 4 kind of resolutions. So there's a resolution made at the annual general meeting, that is referred to just as the annual general meeting. There's the special general meeting. Special general meeting is such as this one. Special general meeting ni kama ya ku strike off a company, mnataka kufunga, mnataka maybe ku extend to expand the company, mnataka ku increase the share capital of a company. No. So special things in the company that have substantive effect on the company structure. Then you have an ordinary resolution. Ordinary resolution, for example, again, increase of share capital ndaitaja hapa pia, because the increase can be just something that is in the conduct of business. Doesn't have to be something major. Then you can have an amendment company articles of association, such and such. No. So that's the ordinary resolution. Ordinary resolution is signed by both. So there is an ordinary resolution by the directors, ordinary resolution by the shareholders. But for a special resolution is only signed by the shareholders, because now this goes back to beneficial ownership. And I want you to write somewhere section 93A of the Companies Act about beneficial ownership. Nataka take note of that, section 93A. 93A in caps. So you have 93A, hiyo iliongezwa. 93A on beneficial ownership. And also take a look about beneficial ownership regulations, but not in in-depth, si lazima ikuwe in-depth. Just even section 93A is enough. And the reason why I take I stress on that is because the beneficial owners of the company, they are the members. For you to be a member, you have to be a beneficial ownership under section 93A of the Companies Act, by the meaning of that act, for you to be a member. The reason why I make that distinction is because there is a difference between a member or a shareholder. So a shareholder is also a member, or a director. Why? Because for a company limited by guarantee, sijui kama Let me ask. At what time do we close so that I see if I can make a presentation ya CR12 mbili ya company limited by guarantee na company limited by shares, so that we stress on how to distinguish between members. Our members ni kina nani?
In my view, Lingera, provided you may achieve the goal of your presentation today.
Yes.
Na hizo challenging terms zenye sisi hatujui because we are not in practice.
Yes.
Hapo utatusaidia sana.
Let me
At the end of the day, if anyone atakuwa pressed, there will be a recording available.
Yes, let me present CR12 mbili. There are two types of companies. A company limited by shares and a company limited by guarantee. So in a company limited by shares, hizi ndo nataka kustress sana, these two types of companies. I will also find one for a public company. Actually nitapresent zote tatu. Also a public company iko nayo hapa. So now this is a private company limited by shares. This is a current CR12. So hii CR12 tumegenerate. So something you have to know about CR12. So I'm just taking you through a CR12. Hata sitaki kuwapeleka sana through the company's registry. Because the moment you know how to interpret a CR12, then you know everything about company. Is a registry actually. You can navigate the 4 registries just by learning about a CR12. So a CR12, it's a letter, it's a formal letter from the business registration service, and it is system generated. So it's a system generated letter from the business registration service to the applicant. So the applicant in this instance was this company. Then it's as per the Companies Act 2015, records relating to the company held as by the company's registry as at 10th March 2026. So the thing you have to know that this company search, official search CR12, is only valid for a minimum of 3 to 6 months. So, and then most likely, for example, banks, they don't take, when they request you for a CR12, you have to give them one that was acquired within the last 3 months. And I will give you a reason why. So I will get back to that when I get here to encumbrances. The reason why they require a current CR12. Hawataki yenye you produce last year, tunataka 3 months before today. So kama umekuja hapa today, just give us a CR12 generated in the last 3 months. So the company name, then the company number. So it is very unique that you can't have another company named as Dadu Hardware Limited in Kenya. No, there's no other company named like this ever in Kenya. Company names are unique, company numbers are unique. Then you have the nominal share capital. So these shareholders, the members. Ndio nikifika kwa maneno ya members, tutaongelelea hii capital. Na ndio maana tutarudi sasa kwa insolvency kuonyesha kwa nini kuna hierarchy. I want us to learn why there is hierarchy in terms of insolvency. This is dated back to when the company was doing business, and I will show you why. So this is 10 million. So the shareholders walipeana 10 million yao wakafungua kampuni, and then the number of shares, number and type of shares, these are ordinary shares. So there are various kinds of shares, many types. Kuna hata sijui the maximum number, but there are many types of shares. But the main shares ni ordinary na preference. So an ordinary share is just an ordinary share that I bought into the company and I want it to do its business. But for preference is for those shareholders who want a preference. Na tutarudi bado kwa the insolvency, tuangalie kwa nini preferential imekuwa keyed in, why there is a preference creditors or preference shareholders, because sasa hapa si ordinary peke yake, but what if it was a preference shareholding, tutaona haya. Then it was dated registration this date is the registered office, very important. You have to have all this, and particularly the email. Sasa kama hii haina email address, is a very big mistake. All these should be there: the telephone, the email address, and something, then the postal address. Now here we are. Now this is very important to what we are discussing today, encumbrances. They are listed here. So let me take you back. Now this is a CR12, si ndio? Hii ni kama hivyo venye wameiweka records relating to the company as at this date. Ndio sasa ukiwa na title deed nayo inakuanga na encumbrances section. Kweli si kweli? So that was the question that Victor raised. So kampuni itself can be owned in land But these encumbrances ziko listed hapa, these are the ones that have only been charged on the company's assets. Unaona, this does not include land. Hizi debentures ziko hapa, hizi further debenture. So hapa wanaandikaga further debentures, charges. There are many times mortgages wataziandika hapa, but you can mortgage a company's assets. Mortgage doesn't have to be land. Unaona, ndio sasa lazima uende uangalie title deed ya kampuni kama ni land. Kama unataka kujua kuhusu land, enda kwa title deed. But kama unataka kujua the company as an asset holder, enda kwa CR12. These are two different places. So when you're checking these as a on deed insolvency, you go for the title deed and the CR12. Fungua zote mbili, angalia. Then you will have an insight. So they had a debenture for how much is 131,240 million. There's another one for what? 60 million, what, 330 million. As in all those debentures ziko hapa. So when anytime insolvency inafanywa, this is na rank kwa secured creditors. Why hata unaona hapo imeandikwa amount secured. Amount secured. Hawa ndo secured creditors yenye tunaongelelea huko. So for example, if there's another one that had not been listed here, these three will take priority and not in pari passu. There's a difference. Pari passu ni preferential ama unsecured. Hapo ndo pari passu inaingia, the pari passu rule. And the pari passu rule is pari passu, when you translate it to English, it says same as, to rank same as. Unaona? So for example, if it is in terms of unsecured creditors, unsecured, tunasema that one ako na $18,000, mwingine ako na $12,000, mwingine $9,000. They will all rank same as each other in terms of their reclaiming, in terms of their claim. So kama pesa ni $5,000 ndio available for distribution, we don't pay one of them first. Hapana, we pay each of them equitably. But hapa kwa encumbrances tunaangalia kuna hii ya 2022 tunalipa hiyo kwanza, ana rank before these. Huyu wa 2020 au huyu wa 2022 ndo ana rank wa kwanza, tunalipa wa 2021, then tunalipa wa 2022, then tunalipa hii 131 million. Now that's how it runs. And again, now back to my stressing on how to differentiate between a director and a shareholder. So hapa unaona kuna huyu director shareholder wa kwanza, Vishal something, then we have the director. We have a director only. Ukikuja kukumbusha kwake shares hakuna, iko blank, hana shares. So a director does not own shares, unaona, but a director shareholder can own shares and a shareholder only. So maybe huyu angekuwa tu ameandikwa jina yake ni shareholder only, then angekuwa na own bado hizo 10 shares ako nazo. So you don't have to be a director to be a shareholder. Yes, and you don't have to be a shareholder to be a director, but you can be both. Yes. And then there is the secretary again. For shares wako blank, a secretary cannot own shares in a company. But I'm not sure about that statement. I will, no, it's not, okay, let me retract that statement. You can own shares in a company, but sasa itakuwa listed. So for example, it is Brian secretary -- shares 0. Then Brian tena mara ya pili shareholder, kwa shares zake zinaandikwa hapo. So that's the thing about a CR12. Now these are private company limited by shares. Now let me open a private company limited by guarantee, and finally a public company. Very fast, in a minute. Let me find one. If the question is that now these are company limited by guarantee. Na sasa tutaona CR12 zao ziko very different, but haziko different sana. So all the way it's a letter to you as the company, blah blah blah, all this way. Encumbrances na listed at the same place. The difference now comes in kwa hii part ya directors and members. So ya kwanza ilikuwa directors and shareholders. Ya pili company limited by guarantee, you can either be a director or a member because hakuna shareholding. Guarantee. So who guarantees? The only person who can guarantee is a member. You have to be a member in a company limited by guarantee for you to guarantee. So unaona hapa kuna 5 directors but only one is a director member. And that's it. That's all about a company limited. That's the difference between a company limited by guarantee and a company limited by shares. Uta realize hapa juu hakuna maneno ya shareholding, ati capital, ati nini, hakuna. Now finally a public company. And more information about like, comment, and share Now, what this presentation does, it gives you a background of now commercial transactions, biashara ya ndani. Unajua sasa ukiingia kwa insolvency inabidi kuongelelea breaking down the business, but you have to understand what was happening when the business was being done for you to understand what happens now when it is dissolved. Yeah, lazima you have a context of background of the law governing the businesses when they are in operation. For you to have a background now, for you to give an overview of insolvency, how to break them down. Because now, yes, I think the point is over. So let me very fast share a public company. So ulikuwa na watu hapa. Ndio hii hapa nimepata. Now this is a public company. And it is allowed to remove in the word public company. A public company is not publicly owned, but it is a public company. Now, again to the business from the business registration service to Madrugada Limited. So using the wazungu fulani huko. Then as that, so this date, so for example this year 12 that I'm now presenting today, this is invalid because imepitwa na wakati 3 to 6 months, even though tulisema. So you cannot produce this one anywhere to be for any use. It's just useless. You have to have one that was producing within the last 3 months. But this is how the company is. Hakuna changes wamefanya. So this is a public company. So the same thing unapata kwa ordinary shares zinakuwa listed hapo, then they list the encumbrances, kuna collateral charge. So angalia hii collateral charge. So mliona huko nyumba kulikuwa na debenture, further debenture. But hapa kuna collateral charge, kuna debenture na kuna charge. Unaona? So you have to know where these are made. So a debenture is mostly in terms of pesa ilikuwa given to you as a loan, and then you're going to repay certain interest. But for collateral charge, it's equipment in the land that is charged. It is equipment, movable property, and Security Rights Act. No. But don't forget that a debenture is also a movable property because money is movable property. Sindio? But kuna hiyo distinction because a collateral charge una place over the company's assets. Sindio? Then debenture una place over your guarantee. That means a guarantee pesa ndawalipa. Then the shareholders, so there's only one shareholder in this company. He owns the whole company alone. Then he's the only director shareholder. Then there are 2 directors in that company. And that's it about a public company. So what I had begun saying that there's a notion I want to remove about public companies is that a public company, so this company was registered in 1964 and up to date, it is owned by one person, mzungu mmoja, and in Kenya, for the nationality. So what I want to remove is you don't have to be, it doesn't have to be publicly owned. It doesn't have to be owned by the government of Kenya for it to be a public company. You can own a public company as a private person. Yes. So that's all I wanted to stress. So the moment you know now, this is a very good background in terms of how companies operate. Actually, unless you're 12, now you have the whole background. So then now when you go back to a presentation.
Pengine I have a question. What is the rationale of issuing out CR12 that are past 3 months?
The rationale is, for example, when you want to change a director or you want to transfer shares in a company, the minimum amount of time it has to take between the first date of my draft resolutions, then you file the same resolutions with the register of, then the resolutions are signed by the directors or the members or something or the shareholders, and then you file the same with the register of companies, or if it is transfer of shares, you first go to the Ministry of Lands to have the transfer deeds. And remember, shares in a company are the same day as you could sell a piece of land. The process is the same. It's just that now the forms and the regulation is different. But if you ask me, if you want to understand how to transfer shares in a company, understand conveyancing first. Now, when you have understood conveyancing, then you can understand how to, as in now, transferring shares in a company becomes very simple. Or you can just start with transfer shares in a company, then you understand conveyancing. Both are the same. Now, coming back to what we were talking about, what's the rationale? After now, this process, maybe with transfer of shares, Ministry of Lands, they have been assessed, you pay the stamp duty, then you take these documents, you file them with Business Registration Service, and then they review that application, and then they ask for directors' consent or shareholders' consent. Is it true that you want to sell your shares? Is it true? So they send you an email. Imagine, that's how they confirm. So they send you an email because we'll talk about the old one. The old one was, if you want to sell shares in a company based in somewhere in Migori, then I have to go from Migori to Sheria House, 16th floor, Upper Hill, niende nifile all these documents, and then come at a later date to come and confirm that it is true I'm the one selling these shares. Ilikuwa operate to kama bank. So that's what they remove. Wakatoa maneno ya banking hall, the company's registry. So everything now is online. You file all these documents online. You file all the payment you pay online, and then when that arrangement is complete. So in regards to what you had asked, the rationale for 3 months is because this process cannot take more or cannot take less than 3 months. This process you change a director, a shareholder, from the date of application and to the date of approval. But they have to drag it until it takes about 3 months, as in it drags itself. So that's the reason. So that now when you're producing a CR12, you show what is there as at now. And for you to show what is there as at now, a CR12 is valid for only 3 months because it takes you up to 3 months to make any changes. So inaweza kuwa this is a CR12 I'm producing in the bank, and yet if it was produced in 2024, there have been changes in the company. So it might be that the person listed as a shareholder here already hata alishauza kampuni, yeye ameleta tu CR12 kwa bank ku withdraw pesa kwa kampuni si yake sahizi. That's the risk about companies. So inaweza kwa CR12 venye naongea hapa, inaweza pata next time hii majina iko hapa, maybe Alicia, Angela, John T. Peter Buckley. Next time maybe in 2030 utapata ni Brian Kimathi Lingera. Then huyu John T aenda na hii CR12 kwa bank, withdraw pesa ya kampuni yangu na aliniuzia. That's the rationale. Yes.
Thank you.
I have a question. Why did you keep mentioning the Ministry of Land in regards to transfer of shares?
Yes. That's a very another thing that I want to remove from. So there is no difference between shares in a company and land. The only difference is that shares in a company is movable. Shares in a company is it's not movable property. That's the first thing. It's not movable property. The second thing about shares and land is they are real assets. They are real assets. So why are they real assets? The first thing you can charge. So for example, hapo kuna comparative section on the company. You can charge the company itself. You can even create a floating charge. The same way you can create a floating charge over land. You can create a floating charge over or you can create a charge itself over the land, the title deed, like we listed to encumbrances section. That's the other thing. And now coming back to your question, why we were saying that transfer of shares is done at the Ministry of Lands is because of assessment of stamp duty. So when selling land, you have to pay stamp duty and capital gains tax. That is correct, Victor? Those are the two taxes that apply. Okay. Before Victor is back with us. And then for a company, when you're selling shares in a company, the tax that mostly applies, mostly, I will use the word most because capital gains tax is flexible. If the government realizes there is a gain on your sale, then they will come for you because capital gains tax is about gaining in a sale. The stamp duty that is paid when a company is transferring shares, and I would like to use a presentation of a transfer deed here in a company to demonstrate, to answer the question in a better manner. Now, these are transfer deed. Yes, let's use this one. I found one. So, Victor, you're back with us?
Yes, I'm back. Thank you.
Yes. So, Victor, we were talking about transfer of shares in a company. And then we were talking about sale of land. And we were saying that the two are similar because shares and land, they are real assets. You can make an encumbrance on shares in a company the same way you can make an encumbrance on a title deed of a land. So, Victor, I don't know if you have a transfer deed for land ready for us as a moment, or we can do it for another time. But I wanted us to compare the two so that we see the similarities and why transfer of shares is done with the Ministry of Lands, not the Register of Companies. The Register of Companies just registers. They register the transfer, but they do not transfer. The person who transfers, the government agency that transfers transfer of shares and transfer of land is the Ministry of Lands.
Thank you, Ringera. I'll consolidate all the relevant documents in a conveyancing transaction.
Yes.
Then we'll be doing a conveyancing.
Yes.
I'll emphasize on that point.
Okay, that's better. So we'll see now a transfer deed in a transfer of land. But now it is similar to this, and in what manner? So we make the transfer deed. So when we prepare the transfer deed, we prepare the name of the company, the figures, words, so how many shares that transferring, and then the shareholders, they sign, the shareholders who are selling to each other, and then an advocate signs. So this is an advocate mwenye ako in-house kwa hiyo tu farm yetu. This is an in-house advocate, ana sign, ana stamp, then sasa hiyo kumaanisha amewitness. Then unaona hii part yenye imeandikwa Kenya shillings 9,000, hii part yenye imeandikwa penalty EPEN Kenya shillings for 60, nitaeleza kidogo. Then the date this was done, then kuna hii stamp, then kuna hii stamp ingine, the same one yenye iko hapa chini. So I want to explain. So after sasa the advocate amestamp huku, mnachukua that transfer deed, mnaenda ardhi sasa. So in ardhi sasa, when you pay for stamp duty on ardhi sasa, and I think this is also relevant to commercial transactions because now at a consolvency, these are the same processes what I take. If there is shares to transfer to somebody so that we revive the company, or maybe it's a voluntary arrangement, or we want to sell this company so that we pay the creditors. This is the same process what I take. So immanent transfer, either the land or the shares, we'll take the same. So I was trying to load a disaster, but in a load polepole, so I'll just go back. So when you go to a disaster, you'll go to non-land, you'll go to stamp duty payment. For RDP, you'll click RDP, then you'll go to stamp duty payment. So on stamp duty payment, this is where the Ministry of Lands wamekuandikia that you have to pay Kenya shillings 9,000. Then there's a penalty of 460 shillings because from the date of assessment, this is 15th October 2025, you should have paid this now 9,000 by the date of 15th 11, yeah, that is 1 month from the date of assessment. That is 1 month from 15th October 2025, and you should have paid this 9,000 by the date of 15th November 2025. So now when we were going to pay for this, it was past 15th 11th 2025. That is 15th November 2025. So we were required to pay a penalty now. Now, they accepted our money and they gave us receipts. Receipt. They gave us a receipt for 9,000 shillings and for the penalty, 450 shillings. So now we are paid for the stamp duty that was assessed by the Ministry of Lands. Na hiyo yote unafanyia nini? Kwa ardhi sasa, and then ukisha apply kwa ardhi sasa unaenda directly in person huko Sheria House kwa Ministry of Lands, kwa hiyo banking hall ya ardhi huko ardhi house huko Sheria House kwenye iko huko kwenye ardhi house iko huko hapa hivi, you go there, then they stamp this. But the good thing with the land, there are a number of registries. See kama companies, there is only one company's registry in Kenya na iko Sheria House, but for land kuna hizi land registries kwa kila mahali, kwa kila county I think there is a land registry, si ndio? So you can go have this done in any land registry. That's something you have to note, whether for transfer of shares or for transfer of lands. But okay, I don't know if I'm confusing you guys, but I hope you're getting the point. Ministry of Lands iko kila mahali, land registries iko in all counties, but there's only one register of companies na iko Nairobi hapa hivi. And that's why it was very important for everything about register of companies to go online, because now hatuwezi now devolve the register of companies. There was no need to devolve that. The only thing that was needed was to localize, and localization means when you introduce ICT, that's it. And now after now tumeonyesha hizi receipts, unaona wana stamp, wanasema payment confirmed, na naika ile ka stamp yenye umeona hapo, hiyo 358 inaisha na 358. Wana stamp tena, wanaika hii stamp pia. Stamp ni mbili hapa ya payment confirmed na 358. Unakumbuka hapa walisema add penalty, ndio hiyo penalty tulilipa, hiyo yenye tumeongelea. And then there is this form D. Form D is presented by the company auditor. Auditor is asked how much was the company worth at that date of the transfer. So auditor anasema it was worth 100 shillings per share, then ana stamp na anafaa kuwa na signature yake hapa, alafu ana stamp na stamp yake. So these are our firm, and then the register of companies, hii unaona ameweka hii hivi vijaandika na pen, ni kumaanisha sasa he has seen that transfer that form D. Now hivyo venye anaichorachora, it's that now this document will not be altered in any way, no, because now you cannot download this document to alter it, so it remains that way. And then finally anakuwekea hizi stamp mbili, hizi imeandikwa ya Kenya na hii nyingine hapa ya date, anakuwekea ya Kenya na ya date, sijui revenue paid or something, stamp duty paid, KRA stamp. These are KRA stamp actually, and that's it. So with that, we can go back to our presentation now. Now we have an overview of how business is conducted, so that when we get back to now these voluntary liquidations, either by the court, by creditors or members, then we can flow. We are there?
Yes, thank you, Ringera, for that practical
I will share samples of all these documents. CR12s are all three types of companies in Konazo. A type of a transfer deed companies nitashare hizi state hata zinaweza tumika anywhere. The good thing with the register of companies, the only document that can be accepted is the original document. So the moment you have a copy, it is of no, and again wanaitishaga tu the director akuja aseme. So that's the good thing with companies, you cannot breach company security that unaweza enda claim company ya mtu, hapana. So I'll share all this, the transfer deeds, hivyo venye ziko, and then we shall prepare now a session on the company's registry, because sasa si unaona leo tume have the insolvency registry, we have to prepare a session on company's registry, then we prepare MPSR. Mimi sitaki kuguza haya purchase kidogo hivi, naogopa, but if it is necessary, if it is in the course outline tutapitia. Iko kwa course outline haya purchase, but kama iko tutapitia hizo tatu zenye ziko. Going back to our presentation, we were at creditors now, the voluntary liquidation. Let me share the screen.
Hire purchase is not in the course outline.
Nice one. Because hire purchase is a bit complicated. Iko na mambo mingi sana na inahusu SACCOS, inahusu some financial institutions zenye hazieleweki. You know the thing with Kenyan law, tuna develop as we go on. After the constitution of Kenya ndo una realize ati Kenyan law imekuwa developed sasa after. So wanafanya test run.
But Ringera, in my answer nimesoma from the screenshot yenye ulituma. Sasa sijui kama hiyo ilikuwa full.
Haikuwa full, iko the full course outline.
Haikuwa full.
Ilikuwa only topic 3 on insolvency.
Wacha tuta confirm about hire purchase. Wacha tuta confirm.
Okay. I have confirmed haiko. Nimeangalia very fast haiko.
Sawa.
Haiko. So the 3 ndo ziko. Companies registry hapo ndo limited liability partnership ziko. So tukifika kwa limited liability, Ngaroya atatuonyesha ya farm yao, aonyeshe venye wana maintain their farm, and then for companies they'll come up with one company, tuangalie how companies are maintained. Then finally tutafanya MPSR and then we shall be good with BRS. Tutakuwa tumefanya ni kama tumefanya Companies Act yote. Not ukirudi kwa act, you cannot relate chenye iko kwa ground, that is now the BRS, Business Registration Service, and the Companies Act, Solvency Act, hivyo. So we were here. Creditors voluntary, it is initiated when the company is insolvent. The resolution of the creditors at a meeting convened by the company, no declaration of solvency. Creditors are primary constituency. Creditors control the apportionment, appointment of the liquidator. The liquidation proceedings operate in favor of all creditors. So all creditors now ni secured. Hawa wako na hii power, hawa ni secured. Please note that. Hawa wenye tumeona kwa hiyo CR12 au kwa encumbrances. Either you are a collateral charge holder, you are a debenture or a further debenture holder, you are a charge holder or something, you are a mortgage holder. Here mortgages, kuna mortgages or companies that are done. Hizo zote they are au ndo secured, nao ndo wako na hii power. Tusisahau hivyo, si unsecured. Then there is liquidation by the court, is initiated by liquidation petition at the High Court of Kenya. Grounds unable to pay debts, just and equitable, public interest. That is now the reasons for the grounds. You have the court issues a liquidation order. The court may appoint or remove a liquidator. That is for now for banks. And I remember we talked about financial institutions being different from other kinds of organizations. It's because CBK may appoint. It appoints now the Kenya Depository Insurance Corporation as the liquidator by the Banking Act Section 35. So those are for banks and financial institutions. Then liquidation of companies on BRS. Now the registry yenye tulikuwa tupitie. So guys, we are on slide 16 of 27. It's 10:20. Do we continue or we can take a break? Or we can continue the evening ama tumalize the 27 slides? I just want to ask for the members indulgence ndio tusikuwa overwhelming pia, so that we get the content hivyo venye iko at a go. We continue.
Javet can go first. Javet.
Victor, you're saying I can go first because I know you're going to say let's continue. I don't know. I think maybe we can take a break. I don't know. Whichever you guys decide, I will flow with it.
So thank you for that.
In my view, we can finish this 8-step BRS process so that if flow from the earlier discussion, this can be our last slide. Alafu, because I'll also be having a presentation on corporate insolvency. Sasa unaona hizo zenye ume highlight hapo in the previous slide, nimeingia deeper, nika analyze even the risk of not complying with the various timelines, because ukiangalia CLE papers wanakwambia some meeting was conducted on the 6th week, kumbe inafaa kuwa within the 5th week. So nimeingia deeper to that extent, so we can take a break after tumepitia hizi 8 steps, so that when tuna resume you'll just finish up the slides, then mimi napiga sasa ile kwa ground venye
Yes.
kuko, alafu tunakuwa hiyo ni another session that I will upload separately. Yes.
So in light of that,
Ah,
let's complete these two slides. So there is this liquidation 8-step process, and there is the priority. So this is the same one we were discussing. This is just a summary. Unaona? So it's ni kama hii ndio the last slide tunafanya sasa hivi. Then we can take a break so that when we come back, we can start corporate alternatives to liquidation. And then we can have Victor, and then we go back to DRS registry tumalizie. Yes, all will be well. So the first step is appointment of a liquidator. Company ceases business except for beneficial liquidation.
or rather, since Ringero, you have started having issues, we can take it from here. My suggestion. So I believe Jebet now Ringera will take over from that slide. When do you propose we start the next meetup?
When were you planning to have it?
In the evening up from 6.
It's okay with me.
Okay, nice. Acha ni notify Ringera. Thank you.